Okay, we're going to discuss the CDD request that's been placed before us. I think Dory's going to start that presentation, and Dory, whenever it gets to that point, I would ask you to stay.
Mayor, there is an ordinance associated with this.
And I will ask you to read that in a moment. We're setting everybody up here. This is a subject that, at least based on the email traffic, has a lot of what I would suggest multifaceted opinions. So as we discuss this today, I am asking everyone to be intent as well as civil in our conversations. This is a matter that I think that we can certainly handle.
Mr. Mayor, yes, we're citizen tree, yes, we're
Yeah,
passed.
thank you, cool.
It's very
This is certainly a
specific.
matter that we can handle as we handle all of the matters that come before us. So that's what I am going to request and enforce as we discuss this. So before us tonight is an ordinance to grant a CDD. Before we have the ordinance read into writing, Dory, could you just briefly describe that people can request this per our state statutes?
Yes.
And that we have a time certainty to respond to this request, is that correct?
Yes, sir.
So
Applicant,
we as a municipality must respond to this
within 45 days
within
of the
45
receipt of
days.
the application.
And so that was done, what, on or about March
February.
6th or February something, so we're in the 45th day.
Yes, and the applicant has been doing their obligatory requirements through Chapter 190 of doing their weekly advertisements. I've seen the postings in the newspaper, as have others. We've gotten comments on that. This is really an applicant-sponsored process to create a community development district under Chapter 190. It is allowed as a special district. I am not an attorney, nor will I pretend to be one on TV tonight, so I'm going to throw a lot of this back to Larry Brown. But really what's in front of you tonight is one aspect of this particular petition, and I'd like to just make sure we're very clear. Tonight, under this ordinance and in this process, you're taking up the application for the CDD. We have the interlocal agreement, which is an additional funding mechanism that we're going to be taking up as your non-action item and getting your direction for that as we go through. But tonight, we're just taking up the response to the applicant and the CDD application. Mr. Arton, who is our special counsel on this, is unable to be with us tonight, but he's been in communication with Larry Brown and Randy and myself. Basically, it's his determination so far that what we've seen in this application for a CDD fits very much in the mold of CDD applications that he's seen throughout the state. The applicant has met the procedural requirements of Chapter 190, and as we are moving through this application, from staff's perspective, it meets the requirements of the CDD.
That's what I wanted to establish before we go further at this point, so now I'm
Yes.
going to ask the city attorney to read the ordinance into the record. But I wanted to make sure that that was established for the appropriate reading. So, and this is my biggest concern, at least as it relates to the CDD application, that's the eminent domain clause.
Yes.
Section 7 excludes parcels. I want eminent domain to be excluded from the CDD in its entirety. I'm seeing that in the future, somebody could build something and it's long past the developer, it's sold, and the CDD could come along and say, I want to have eminent domain over the properties in the CDD. I don't want them to have eminent domain. I don't want them to have eminent domain in any respect. So the question would be is if this could this be amended? It has to obviously pass our commission, but could this be amended to just say that the CDD has no powers of eminent domain?
You could not do that because that would be in conflict with Florida law. If you grant the petition by ordinance and establish the CDD, under statute 190.011, there are enumerated a number of powers that a CDD automatically has. One of those powers is a limited power of eminent domain. It's not as broad as the city's power. For example, they couldn't condemn to build a public recreational facility. They have eminent domain, but it's limited to properties inside the district. In other words, properties that have already agreed to join the CDD.
Right, I understand that, but this is my confusion, because I've heard, I think, two legal opinions. I don't want to say from your team, but and/or staff opinion that says the process for eminent domain, while grantable under the state statute, is something that we could exclude
No.
within the CDD.
No, you could not exclude it, in my opinion. That would clearly conflict with the general powers in 190.011 as to properties that are part of the district. Now, the donut hole properties, the petitioner has amended to add section 7 to clearly point out that properties that are internal to the boundaries, they cannot be condemned by the district unless the city commission in the future issues a resolution permitting it. So any property in or outside the CDD under the statute, if it's not part of the district and the CDD wishes to condemn for a permitted purpose land that's not part of the district, they can only do so if the city commission in the future issues a resolution permitting them to condemn.
So, okay, other questions? That helped me.
Okay.
Commissioner Cooper?
What I'm trying to make sure is absolutely clear to me is if you look in the petition, item number 8, the bottom of that page says the establishment of the district is based upon the assumption that an interlocal agreement between the city and the district pertaining to ... payment of certain economic incentive payments from the city to the district will be entered into immediately subsequent to the formation of the district by city ordinance. And the thing that I'm trying to understand, Mr. Brown, is do the assumptions that are identified in the petition by the petitioner for the CDD have any authority? And if so, do they have authority relative to the EIP payments and the interlocal agreement that we're going to talk about tomorrow? And I had asked the question of Mrs. Carpenter. Yes.
Please, let's not say tomorrow. It's gonna be a long night.
Next meeting is what I did for the interlocal agreement.
So if I could add to your question, Mr.
Well,
Brown,
I
you
just
finish your point.
Yeah, I just wanted to say that I know when I asked Mrs. Carpenter, she did say that that it was conditioned. I don't, if I misspeak, I thought you said it was conditioned upon getting the interlocal agreement. Maybe we'll ask you that when you're up here. But basically, I'm trying to find out what authority do your assumptions have? What authority does your petition have relative to our action? That's what I'm trying to understand.
Well, here's what I would say in response to that. Number one, this public hearing has been advertised, and the statute requires that after they file a complete petition with all their exhibits, the city has 45 days within which to hold the public hearing. So you still are on first reading, and the effective date of any ordinance at the second reading could be extended to allow for finalization of ILA negotiations, or you could defer second reading until such time as you see if you can come to terms on an ILA.
But may I ask a follow-up question, Commissioner Cooper? Mr. Brown? May I? Oh, yeah.
Yes, sir.
It just so happens to be in the petition. We could modify, or could we modify the ordinance under section 3?
I'm just trying to understand.
No. I'm with you. I have the same concern that you just raised. Could we, under section 3, modify that to say that this CDD is not predicated on an interlocal agreement?
It's your ordinance, Mayor. So the ordinance, this is first.
No, I know it is mine, but this has been carefully crafted by
Yes.
numerous people.
Yes.
So the grant of a petition, which says a copy of which is attached, or the real property is hereby granted, I'm reading from the ordinance, because that to me is the only thing that has legal standing, at least once I vote on it. I don't know that I'm voting on a petition. I'm voting on an ordinance. So embedded in section 3, must I respond to and/or fulfill an interlocal agreement?
Yes.
But I don't have to.
You don't have to, but that's what they prepared this ordinance. They, at our request, graciously did add section 7, which puts us in the best position we can be in with respect to excluded parcels or eminent domain. And they also clarified in Exhibit C, way at the end, the special powers in 190.012 that they will exercise. That's on the last 2 pages of this package. So they've added that. My assumption has been, you're not going to enter finally this ordinance unless and until you're also satisfied with an ILA.
But I guess that's an assumption that I think is,
Like to decouple.
yeah, I think it's a very risky assumption. And that may be what's been petitioned, but I don't know that that's what the will of this commission is going to do.
And perhaps at first reading, you would direct.
No, and I frankly don't like doing it that way, just to be blunt. I don't like to do things and say there's open ends. I like to have first reading be as personally, as close to the second reading as possible. So
It could be amended
I
tonight.
personally, what did you call it, IL?
Interlocal agreement.
The ILA is DOA for me, right now, as it is.
Mr. Mayor, can I really just make a point there then?
And that is just based on the terms of that, so I don't wanna be put into a position that says I must.
But we're not agreeing to those terms.
No,
We're
but-
just saying it's got, the ILA, by the time we get there, can be rewritten, we can make any adjustments we want to. What we're saying here is, we enter into it, but the ILA right now doesn't exist in any form.
True.
Official form, I mean, it
So
exists,
I'm-
but
I'm-
you can
I mean,
modify.
Is that typical, but let me ask Mr. Brown, maybe he doesn't know. Maybe our other counsel might know, unfortunately he's not able to be here tonight. I personally am supportive of granting a CDD, because that gives certain powers to a group of people that say they want to be part of that,
Mhm.
personally. But I don't want to be beholden, because I may, personally, I'm speaking for myself, as one vote. I may not want to do an item. I may want to do something completely different. I may want to do nothing. I don't know yet. I don't want to be forced by making a CDD decision that I must do an ILA. So there has to be a vehicle that would allow us to grant a CDD, and let me say it this way, that we would draft a CDD ordinance that would let us grant that in such a way that whether a CDD happens or not, becomes CDD, it's their power, et cetera. But I don't know that there was an ILA done for Celebration in Baldwin Park, for example.
No,
But the powers that gave them a CDD, I would almost argue for a more neutral, a more vanilla, if that's considered plain, ordinance that says, here's the CDD with the exception of the eminent domain. And then the discussion of an ILA may take days, years, months, who knows how long. I mean, just like the discussion of an ILA with Orange County for Sunrail took 2 years.
Got 2 heads nodding on that one, because that's
Well,
where I'm at. They should have coupled.
So if that section, and I guess my question is, does that section even need to be in here?
this is a vanilla ordinance, but for that provision and the things that we've asked for them to put in, which they did put in. The petition itself, as was explained by Dory, the petition is complete. It's what you see with respect to CDD establishment. The difference in this CDD and any other CDDs that I've worked with, and I represent 5 right now, the difference is, and there's nothing wrong with it, there's nothing wrong with being innovative, but
No.
this ILA is something that I've never seen before. And I've worked with the Disney Celebration CDD for the school board down there, and I'm very familiar with a number of CDDs. It's very innovative to do the ILA. So it would be very easy to simply, for first reading tonight, modify section 3 so as to grant the petition, but specifically carve out and accept the provisions that you've mentioned before, tying and conditioning the grant to the interlocal agreement.
We're not even doing that. I'm arguing that if the petition asks for it, that's creative and they can certainly ask for it, but I don't know why I need to grant that. So I don't want to deny the CDD if I don't want to grant that specific piece. That's where I'm
But you
trying
do have to
to.
grant the petition to create the CDD. but
I do.
You
But I
don't
mean, a
want to-
petition could be very simple. It doesn't have to be, I'm assuming there could be a simpler. Petition.
I'm gonna step in if I may. That clause that you're discussing with the ILA was actually done at the request of our special counsel to take this from a completely vanilla petition and make it specific to the fact that there is the CDD and there is this subsequent funding mechanism through an ILA. I would have to ask Ms. Carpenter and the council, that was a clause that was added at the city's, at our request
By
because.
Mr. Art?
By Mr. Arton, because it was very specific to the CDD. So it was very vanilla, and we actually probably made it more of a twirl, so to speak.
So my request goes back to this, does the CDD, when it's enacted according to statute, have to have a funding mechanism associated with it? Is that,
No,
does
it does
that
not.
meet that? It doesn't, I mean,
It
you
doesn't
can create a
have to.
CDD with no funding
Yes,
mechanism,
sir.
right? I mean, that's entirely
And
possible.
then down the road, issue a bond anticipation note, and, I mean.
So he's not here to speak to why he suggested that, council. on that.
Because it was specifically a part of the connectivity between the CDD and the funding mechanism that they were requesting. And he felt that the CDD really needed to kind of lay out the framework for the funding mechanism that they were requesting. He and I had, and I think Larry and Randy might have been in that conversation that we had about why that language was incorporated. And he just felt because it made it, it really was it was the uniqueness of this CDD application that there was an interlocal agreement with an alternative funding mechanism associated with it that were connected. And I'm just telling you, that was the conversation we had.
And I don't know if that's just because that was petitioned that way, or if that's just, he's not here to speak to him, council.
Right.
You're welcome to come up, I don't want to stop you, but I'm not I mean, you're representing somebody else, so.
Yes, what we're representing is to be formed CDD. I spoke with Ken Arkin just an hour or two ago, he couldn't be here, but we would be happy to strike that from the petition. The ordinance says, I think as amended, we'd be happy to strike that. He put it in because he realized the concern was that everyone was looking at this, and as are we, as an additional funding source. It certainly is not anything that is required to form the CDD or to approve the interlocal agreement. It generally is in there to talk about, you give an estimate of how you're going to plan, what's going to happen in there, and that explains one of the mechanisms for funding it. So we would be happy here to strike that and have the petition submitted with that change made today.
It's just doing here at the dais that makes me crazy, because the question is, I want every reference out. I don't care if it's this one and 5 more, it doesn't matter where it is. I don't want to get these 2 documents coupled at all. And I want to get that language out of there, and I don't know how to do that. And I don't feel good doing it without looking at it.
But, I'll just play a little bit with devil's advocate here, because I'm saying, our attorney is the one asking for it to be in.
Not me, Ken Arkin. And I
Who's
would-
got experience doing this? No, I'm not against this, but I'm saying, I find it interesting that we're getting comfort that the applicant's attorney is saying we should take it out.
We should tell it to our
No,
attorneys.
I'm very uncomfortable that our council's not present.
I
Our
agree.
trustee has a good reason to not be here.
I just don't know another time where we'd be happy that our council adds something, the opposition council says, yeah, take it out, and we're like, okay.
Well, whatever, I kind of agree with her.
Well, it put me to the place where I was going to have to vote against it, totally, because I don't want them coupled.
I mean, I honestly agree with Larry, but I honestly don't think it has any legal precedent being there. The only requirement is that you provide the distribution of the public and private land uses within there, and this was just explaining that the interlocal was assumed to be funding them. Whether it's in there or not, I don't think it has any value whatsoever to approving the ordinance.
I agree
But
with that.
it would easily, we would be happy to strike it or leave it in, whatever your council decides.
Larry, just to, I'd like you to address, if you can, the concern that we keep hearing in the community, we receive emails on, in regards to CDDs defaulting, the impact that has on the government, the governmental authority, and how that plays with municipalities. Would you just address that? I think that when people hear that CDDs default, that cities go bankrupt, cities are on the hook, and cities, see that. So can you just address how that all plays out?
Without any question, except to the extent that the city agrees otherwise, if that CDD, and let me be clear, the CDD itself doesn't default technically. It's the landowners in the CDD who fail to pay their assessments. The CDD has a trust obligation with the bond trustee to collect assessments and pay them over to the trustee. If the landowner defaults in payment of the debt assessments, then the CDD has an obligation under the trust indenture to foreclose that land. So the city is not at risk in any way, zero risk, if no matter who defaults within the district, the city of Winter Park will never be liable under those bonds that they've issued. The city will never be liable for any contracts or, any other indebtedness of the district itself or any landowner within it unless we voluntarily undertake to do that. Now, if the CDD is dissolved or terminated, the city, at its option, can agree to assume the responsibility to provide services, and in that case, will assume the bond indebtedness, but only to the extent of the services it's taking over. So, I mean, you never, without your voluntary agreement to do so, become liable for any obligations.
Now, I understand that the interlocal agreement adds an additional layer of
Yes.
complexity.
Yes.
We will get to that. I don't want to confuse the two issues here during this discussion, but we will talk about that later. But I just wanted to clarify that for those here and those listening.
Was that clear enough, though?
It was.
Zero risk.
It was clear.
Commissioner McMackin,
I
follow-up.
want to, because I had it on my list as well, and the only other question, I believe you answered it, it would be revolving around utilities and roadways as such, so that you are saying, if there is a default, the city could come in and assume maintenance of those common areas, you call it that.
They would have to
If
assume
we- If we assumed.
The debt obligation.
Okay.
Not
But
the
we-
entire debt obligation, the debt
Just a
obligation.
portion
was-
related to what you're taking
Well,
over.
other than stormwater, what is the CDD assuming in terms of services? They're not doing police, they're not doing fire.
Let me also add that the way typically.
And I mean, we're still doing stormwater, we're just fine, building, am I correct?
Right, typically the CDD will develop roads and then dedicate them to the city.
Right.
Once so the city owns them pretty much from the get-go, once the
Right.
roads are constructed to the level and standard that you are willing to accept. So really the bond indebtedness has nothing to do with that point, because they're your roads.
Thank you.
And then the last question I have, Randy, is one of the things it says is this the best alternative available for delivering the community development services and facilities to the area that will be served? And my question in that regard is, can the city of Winter Park provide infrastructure customarily provided by the city within our current funding or impact fees that would come from this development?
Not in 1 year or in 2 years.
No, but as needed to accommodate the development.
Right, we do not have in our budget to put all of the infrastructure in there needed to serve.
At a basic level that we would do. Okay, thank you very much. That's all.
Does the applicant wish to have comments or commentary before we've been debating things, obviously, from the get-go?
I won't go through a presentation. I think you've heard plenty from us over the last week or so. The only comment I want to make, and just to make sure.
Please identify yourself for the record.
I'm sorry, I'm Jan Carpenter, Latham, Sugar, Eden, and Bodine. We represent the petitioner, and if and when, we assume it will, the CDD is formed, we will represent the CDD as the government. And the developer, Benjamin Partners, has their own counsel. We do not represent them in any fashion in their land use, their development plans. The CDD will have its own team of professionals, most of whom are here, and you've met or spoken with many of them. They're here to answer any questions. But just understand that it is a true government, not quasi-government, just special purpose, which is limited purposes for this one small area, and go through an audit process. The Board of Supervisors all have to follow the same ethics, sunshine law, public records law that you all do. So those folks have certain responsibilities. So when there's comments about, quote, the developer, you have to remember that the developer doesn't control once the CDD is formed for these specific items. And if this goes on in perpetuity, whether the developer changes, as that comment went down the road, or as things happen over time, the CDD will remain in place with its own board.
The question is, there's roads that are in existence
Yes, there's
today in the
roads.
property?
Yes.
So I'm trying to understand if those are city property today, irregardless of what happens to the CDD, And/or does the CDD accept those as part of this, or they're gonna try to accept that?
The CDD is going to rebuild those roads and then dedicate them to the city once the city accepts them, those 3 major roads that go through.
So, but I also heard you said there'll be no private roads in the CDD. I don't know if
The
you
CDD,
misstated
the
that or not.
CDD cannot build private roads.
Okay.
And so
So
that's.
other people could.
Yes, what happens is CDDs that are residential in nature will sell large tracts to a private developer, and the private developer
May or may not do something.
may or may
in
not
that
do,
area.
yeah, he'll do private roads in his little area, and that could have a gate. And the public road, the CDD builds, will just lead to the gate. But given the prohibition against private streets, I mean, I think that per se limits the types of gates that are in the statute to gates that would, for example, a swimming pool, there could be a gate to keep people out, not necessarily.
Yeah, that's the general reason for the general powers of the waste collection is to be able to go clean streets, pick up the waste in the streets, gates, you have gated pools, gated areas.
And I wanna
You
add-
have to have it permitted if you're going to build a gate.
That's right, everything that they're building will have to be permitted through Winter Park land development codes. But I want to emphasize that the CDD, Mayor, cannot take away city property. So if there's a city road through there, they can't condemn or take or destroy. They can rebuild and make it better. They can't take away a city right-of-way road.
Okay, thank you. Commissioner Mann, did you have a question?
Dan
Ms. Bells, if you'd identify yourself for the record.
Dan Bellows representing Benjamin Partners LTD. The applicant. Bennett Avenue will be a static right-of-way that exists today. We were requested of the county in conjunction with the city at DRC to realign Bennett where it hits Lee Road so that it lines up with the executive across the street. That's why it bends. It was a request to us. But that road would be redone by the district and maintained by the city. Lewis Drive is an existing city right-of-way. It is what is to be the main street through the project that is currently a city right-of-way, that is currently being partially improved right now and would be completed by the district and would be continued to be maintained by the city. Glendon Avenue runs east-west, comes right out the front door of Park Green and goes straight to 1792. Existing city right-of-way would be improved by the district and maintained by the city. The county had already vacated a portion of Benjamin Avenue and a portion of Lowell Avenue, and that's done and gone. The Benjamin Partners would be coming before this board in the future. We're actually doing the surveying to ask for other portions of Lauren Avenue and other portions of Benjamin and Elvin to be vacated. The commission could choose to do it or not. If you do, then those areas are going to be improved by the private developer and the district, and would be maintained by the district or the private developer. But all of this is in conjunction with, as much as the city wants to take on, when you want to take it on, I think Ms. Carpenter could answer, the district is willing to turn it over to the city, or the district can maintain it for the next 30 years.
That's helpful. We've spoken to some of the roads. I don't know if that, all of the roads that are in the district or not. That's all of the roads?
Yes, sir.
Okay. Thank you. Further commission discussion. You had nothing else, Mr. Zimmer?
No, nothing else.
Mr. Mayor?
Yes.
One thing that has become very obvious to me during recent discussions is that with or without an agreement to revenue sharing, we have a lot of details that need to be worked out, and I think those need to be in the form of an agreement as to how we're gonna operate going forward. And just one of the things that happened to me recently was the discussion of the baseball stadium versus how do you incorporate the baseball stadium into the development. And our staff and I legitimately felt that the way that we would do that and how we were going to work together was that we would have substituted some other part of the entitlement, and the developer had a very different impression of how we were gonna move forward. And I'm not saying who's right and wrong, I'm saying that this is very, very complex, And if we don't document how we are going to work together, we are going to be, it's not going to be pleasant for many years, and that would be a tragedy. So it just seems to me that there's a lot of people, that there are a lot of unknowns here. What Orange County said is not, necessarily getting filtered all down to what we need to know to make this project work. So all I can say is no matter what, when this CDD is in place, we really need to have some good interlocal agreement that defines our relationships and how we're gonna move forward. When it comes to conditional uses, are they or are they not going to be here? When it comes to parkland, are we going to look at one or the other? And whose comprehensive plan? I noticed in the petition, it says the Orange County Comprehensive Plan. In our pre-annexation agreement, we agreed to take the entitlements from Orange County and operate within their land use code. We never said we would defer policy to a different comprehensive plan. And that's the sort of moving parts that I'd like to see us get lined up in some kind of agreement. Sorry. Yes. Did you want to comment on that? 'Cause I understand until we put our zoning on it, as long as we haven't changed zoning, I guess it stays.
No, well, when that was drafted, it was right around the annexation time, so it was the Orange County comp plan that was adopted pursuant to the annexation, so it is whatever it is.
Okay, but are you comfortable then that while we have accepted the entitlements and the building codes to builders, when there's something that's not addressed or then we defer to the Winter Park codes to the streets not being gated or policies?
Well, if I may, I think this is really the heart of the CDD versus the developer. The CDD is purely a government that builds, maintains, and operates infrastructure and improvements for the public. So the CDD has nothing to do with land use, zoning, requesting road vacations unless we're going to be building it. But from that standpoint, it's purely your typical development approvals that the developer will go through as if he was building anywhere else. So that has really nothing to do with the CDD.